The judiciary is sometimes portrayed as the non-political branch of American government. In our idealized vision of the courts, federal judges and justices are supposed to be impartial arbiters of the law, issuing rulings solely on the basis of neutral legal interpretations. Unfortunately, this is far from the case. The judiciary is an inherently political branch, just like the legislative and executive branches. The federal judiciary is both powerful and political because it decides in real-world terms what the Constitution actually means in practice. As we learned earlier in the semester, the United States Constitution is quite short compared to other countries' constitutions, meaning that it lays out a framework but leaves a lot of detail to be figured out by other means. And many of the provisions of the Constitution use vague or ambiguous wording that might have different meanings to the framers, and certainly have different meanings to Americans throughout the country's history. But there's deep disagreement about how justices should use their power of legal interpretation to apply the Constitution. Constitutional originalists, sometimes called strict constructionists, argue that the Constitution should be interpreted according to the original intent and meanings of the framers of the Constitution. While some strict constructionists concede that it can sometimes be difficult to determine exactly what the framers intended, they argue that it's the job of justices to do their best to abide by the original meaning of the Constitution and not substitute their own judgments about what would be best for the country with the judgments of the framers. Advocates of a living Constitution, on the other hand, argue that our understanding and interpretation of the Constitution should change over time in line with changes to society. Related to this is the debate over judicial restraint versus judicial activism. Advocates of judicial restraint place a great deal of emphasis on precedent and stare decisis for providing stability and consistency in the application of the law. Stare decisis is Latin for let the decision stand, and gets at the idea that current justices should respect the precedents established by prior courts in prior cases, that once a decision has been made, similar future cases should be decided similarly. Judicial activists argue that while precedent and letting previous decisions stand are important legal principles to abide by, they aren't necessarily the only or most important principles. Judicial activists argue that the courts have an important role to play in furthering justice and overturning forms of oppression that were tolerated in the past, and that precedents that get in the way of justice should not necessarily be respected. Now, these are interesting philosophical debates, but they also have a deeply political element to them in the sense that one's political viewpoint tends to influence one's views on judicial interpretation. For a long time, when the Supreme Court was dominated by more liberal justices who were considered judicial activists, making sweeping rulings in favor of things like abortion rights or greater protections of the criminally accused, conservatives howled that the Supreme Court was overstepping its bounds and should be more constrained in its rulings. Now that the court has a firm conservative majority, it has been aggressive in overturning things like voting rights laws, campaign finance laws, labor laws favoring unions, and other policies that many conservatives would like to see overturned. Now it's the liberals that are arguing that the court is overstepping its bounds and should be more constrained in its rulings. In other words, when your side has power in the judiciary, you're much more likely to be okay with judicial activism, whereas judicial restraint starts to look a whole lot better when the other side is running the show. The stakes of this argument over judicial activism versus judicial restraint are very high because the Supreme Court and other federal courts have the power of judicial review. This is the power of the courts to rule the actions of other branches as unconstitutional. So, for instance, the courts have the power to rule that laws passed by Congress violate provisions of the Constitution and are therefore null and void. The courts can rule that some action taken by the president, usually through directions given to executive branch agencies, are violations of the Constitution and therefore must be overturned. And the courts can similarly overrule actions taken by state governments. The power of judicial review is somewhat controversial because it's not entirely clear that the framers were wholly in agreement that the court would have this power. It's not explicitly detailed in the Constitution. Instead, the court claimed this power for itself in the incredible case of Marbury versus Madison. This case was important in all sorts of ways, but was critical for establishing that judicial review was a legitimate power of the Supreme Court. The details of the case are a bit complex, so I've provided a link in this slide to a video explainer of Marbury versus Madison that explains the case in an understandable and also humorous way. I encourage you to watch it so that you have a good understanding of this landmark case. With the power of judicial review, the federal courts are far more than just neutral arbiters of the law. They have enormous power to say what the law is and what it is not. They shape policy in important ways. Just in the past few years, the court has made incredibly important decisions in the areas of civil liberties and civil rights, election law, immigration, environmental law, workplace regulation, and criminal justice, oftentimes striking down policy put into place by Congress, the President, or the states. Because the judicial branch has substantial power, it should not be surprising that the selection process for federal judges is highly political. Because federal judges serve lifetime appointments, presidents have a tremendous opportunity to leave a legacy by populating the federal courts with judges who share the president's political philosophy. Republican presidents tend to appoint conservative justices. These justices are more likely to rule in favor of businesses that challenge regulations they believe to be improper, or business owners in disputes with their workers or customers, law enforcement, and traditional understandings of civil liberties and civil rights. Democratic presidents tend to appoint more liberal justices. These justices are more likely to uphold regulations on businesses intended to protect consumers, workers, or the environment, more likely to rule in favor of defendants arguing that their civil liberties have been violated by law enforcement, and more likely to take an expansive view of civil rights and civil liberties. All of this is a long way of saying that federal judges appointed by Republican and Democratic presidents tend to rule very differently. There really is no such thing as a neutral arbiter of justice, because our views about what justice entails are deeply shaped by our broader political ideology. The president's legacy with the judiciary is shaped to a certain extent by the Senate, which confirms the president's selections to the courts at all levels, the district court, circuit court, and Supreme Court levels. As we've seen in recent news, confirmation battles over a president's judicial nominees are very common, especially at the Supreme Court level, because seats on the Supreme Court open up so relatively infrequently. So every vacancy on the court represents a precious opportunity to impact the political balance of the court well into the future. Confirmation battles over a president's judicial appointments are commonplace, because once a judge is confirmed, that decision is firmly locked in and is basically impossible to undo. Once on the bench, justices are immune to some degree from popular and governmental pressures. All federal judges serve lifetime appointments. They can only be removed by the same congressional impeachment and conviction process that applies to the president. But this is an extremely rare remedy. Out of thousands of judges who have served on the federal bench in American history, only 15 have been impeached by the House of Representatives, and 4 of those were acquitted by the Senate. So impeachment is not a particularly useful remedy for the elected branches of government to simply try to get federal judges to adopt a more favorable outlook on laws passed by Congress. Further, Congress can't threaten federal judges with a reduction in salary as a way to get them to fall in line, as the Constitution specifies that judges' salaries can never be reduced. So the process of presidential nomination and Senate confirmation represents the one chance to get it right, so to speak, to place the right individual on the bench.